Hi, I'm Peter Afrasiabi. The program you're about to watch, The Curious Lawyer, Sex, Videotapes, and Lies, was recorded a few years ago, but I've confirmed the content is still current and timely and reflects the current state of the law. I hope you enjoy it. Hello, I'm Peter Afrasiabi, host of the Curious Lawyer series. The Curious Lawyer series of continuing education videos for lawyers is a fun, whimsical walk down different paths of the law that you may not be familiar with, that are new and interesting, and that let you get a little insight into different sides of society, of our country, of our legal system, through exploring, in an educational setting, of course, different areas of the law. Today's Curious Lawyer program is Sex, Videotapes, and the Law. And we're going to have a walk through sex law, the law regulating sex and human sexual conduct, voyeurism, videotapes, recording people and the like, which is our videotapes. And in homage to the movie Sex, Lies, and Videotapes, our program is Sex, Videotapes, and Lies, we're going to look at lying and the intersection of lying and the law. Do you have a right to lie? In what context can you lie? Can you not lie? So let's get started with the Curious Lawyer today on sex, videotapes, and lies. We are going today to do an overview of laws related to regulating sexual behavior on our sex component of this program. And we're going to talk really quickly about laws regulating adultery, incest, prostitution, obscenity, peeping Tom laws. All of those are categories with a broad umbrella, within and under the broad umbrella of sex and sex law. From there, we're going to shift, and there's a blending between sex and our videotape component, because we're going to look initially at the recording of pornography on videotapes. So we're dealing with sex and videos in that sense. And we're going to shift to just pure non-sexual based video recording, such as your rights to record video in public. What are they? What's the scope of the public right to record? And of course, let's shift to the private side. How can you record people, photograph them, video them in private? What can you do with it? And then what are the consent standards for videoing? And here we're going to pivot back to sex briefly again and look at consensual sexual recorded videos and then the public release of them. And this is an issue that's become massive in the law recently, of course, under the phrase that the media has used of revenge porn. And we're going to look then at revenge porn laws designed to protect people against the dissemination of even consensual videos to the public. Finally, we're going to land on lies, and we're going to look at the constitutional right to lie in some context, and we're going to look at perjury and lying to the FBI as a crime. So let's get started with sex law. Here's our overview of the law relating to sexual relations. There are federal and state laws, both of which, under both regimes, relate to and regulate sexual behavior and the filming and viewing, ultimately, of sexual activity. We have criminal legal regimes, and we have civil legal regimes. Within the legal regulation substantive area, we have laws related to statutory rape, incest, bestiality, prostitution, adultery. We also will look at obscenity and copyright law. And we even have trademark law related to trademarks in the sex and sexual space of commerce. Let's start with adultery. Is it illegal? Well, it remains a criminal offense in 21 states as of 2017, and it's a felony in 2 of them. Many states have repealed, however, criminal laws prohibiting adultery in the last several decades. Let's take a look here, for example, at Utah's Criminal Code 76-7-103. A married person commits adultery when he voluntarily has sexual intercourse with a person other than his spouse. It's a Class B misdemeanor. Massachusetts is similar. A married person who has sexual intercourse with a person, not his spouse, or an unmarried person who has sexual intercourse with a married person shall be guilty of adultery and shall be punished by imprisonment in the state prison for not more than 3 years in jail, for not more than 2 years, or by a fine of not more than $500. You can see there Maryland's got a similar one where the violation's a misdemeanor and you're going to be fined $10. The question these statutes get to, however, is there a constitutional right at issue here? And challenges based on privacy rights of a person to engage in extramarital sex, it turns out, have been rejected because adultery laws have survived rational basis review given the state's interest in protecting the family and preventing disease. You see here our case site. It's Oliverson versus West Valley City at 875 F Sup 1465. And that comes out of the District of Utah in 1995, where the court simply found that the constitutional right of privacy to have an extramarital affair that would allow you to engage in adultery and not be prosecuted or punished for it within a legal regime fell under rational basis review, because the state's interest in protecting the family unit and in encouraging and preserving family units and in avoiding the dissemination of disease were sufficient state interests to make the statute pass rational basis review. So it turns out you don't have a constitutional right to engage in adultery if you happen to be in a state that makes it illegal. Let's shift from adultery to incest. And the legality of incest varies by jurisdiction in degree more than scope. The typical code we can look at here is California Penal Code 285. And California Penal Code 285 makes it a felony to engage in incest, which is defined as sexual relations or marriage between close relatives. Now, the question, of course, when we're talking about degree, not scope, is what types of relatives may you have sexual relations with, what types of relatives may not have sexual relations with each other. California's definitions prohibit and define as incest sexual relations between parents and children, grandparents and grandchildren, or anyone else with an ancestor-descendant relationship, like great-grandparents and great-children, for example. Siblings, half-siblings, uncles and aunts, nieces and nephews. And the definition from the code is based upon blood or half-blood relationships. And so it's pretty broad. But let's look at our next side. What about the idea if you have consulting adults who engage in incest? Do they have a constitutional right to do it? It turns out this has been litigated. It's been litigated in California, and the case was People versus McKeevoy. It's at 154 Cal Reporter 914, and it's from 2013. What happened here is that the defendant, who was arrested and indicted for engaging in incest, claimed that the sexual encounter between himself and his sister was consensual, and that consensual sexual activity, even if between siblings, had to be a protected liberty interest within the Constitution. And factually, we can assume for purposes of this opinion that everyone agreed it was fully consensual. The court, however, rejected the challenge and held, and this is kind of similar to the Utah law that we talked about earlier, or the Utah Federal District Court case, that there actually is no protected liberty interest that would deny the state the ability to regulate and prohibit incestual sexual relationships, even if it's consensual between the adults. And here you see the similar rationale being used by the courts for the underlying policy reason to justify the absence of a constitutional right and to justify the power and the presence of the state's police regulatory powers. The quote is, and this is from page 445, California's interests in protecting the integrity of the family unit and protecting against inbreeding are sufficiently important to justify Section 285's incest prohibition. So, there you have it. No right to engage in incest between consensual adults within one's claimed constitutional rights. Now we can shift to prostitution. Prostitution is criminalized in various ways at both federal and state levels. And the criminal laws attach both to the prostitute and the customer, as well as what are known as pimps or brothel owners. All participants in it can be regulated and subjected to criminal punishment. Let's take a brief detour quickly to some federal examples of federal laws that touch upon prostitution and prostitution behavior. And they're actually fascinating laws to look at as we do our little curious lawyer walk down this path. First one takes us to the immigration context. What if you have a situation where someone's coming from a foreign country, they're seeking admission to the United States under the refugee laws, or they're seeking to become a citizen in the US, and it turns out they had engaged in prostitution in their country of origin. What if it was legal in their country of origin, as it's legal in some places around the world, obviously, and so they had engaged in what was lawful legal behavior within their legal jurisdiction? It doesn't matter. If someone has been a prostitute abroad or engaged in prostitution, even if legal in that regime, here, under our immigration laws, they are inadmissible if they've done it within 10 years of seeking to come to the United States. Another example of a federal law that touches upon prostitution is that if someone engages in prostitution within a reasonable distance of a military base, you can be arrested and indicted by the U.S. attorneys and face up to a year in federal prison. That's 18 U.S.C. 1384. Let's shift now, as we continue our talk about prostitution, to some state examples. And for this purpose, we're going to look at California law again, and we're going to look at California Penal Code sections 266 and 647, which together outlaw prostitution and pandering or pimping. Section 647, subsection B states, quote, prostitution includes any lewd act between persons for money or other consideration. Now, the California Supreme Court has expanded upon this in terms of interpreting it, and in the case of People versus Freeman, reported at 46 Cal 3rd 419 at page 424, and this is from 1988, the California Supreme Court said, quote, the genitals, buttocks, or female breast of either the prostitute or the customer must come in contact with some part of the body of the other for the purpose of sexual arousal or gratification of the customer or of the prostitute. So there is that nexus kind of requirement in terms of bodies connecting in that way in order to trigger a prosecution of a prostitution or lewd act. Now, the issue in many cases then, of course, coming from the Freeman case, is what sexual conduct is considered lewd and what is the level of physical touching required to trigger the lewdness bar, so to speak, in order to be prosecuted. And this actually starts getting to the line between pornography and prostitution. And so People versus Freeman is a fascinating case. And as we unpackage it on the next slide, you'll see what it was about. Freeman involved an adult producer of film contents, of adult film context, what's conventionally known as porn. And this porn producer was charged under these anti-pimp procurement laws relating to paying 5 women to act in non-obscene pornographic films. So he had, paid them to make the pornographic movie, and it was not obscene, which is, we'll talk about shortly, which is its own separate category of content that can be prohibited. But nonetheless, he was indicted under these prostitution laws for paying women to engage in sex while making the movie. And this case went to the California Supreme Court, and the California Supreme Court said that the anti-pimping and pandering laws were not intended to apply to adult movies where the paid person was acting and hence were engaged in protected expression, the act of acting, in other words. And that was what they were given money for acting, as opposed to being given money to satiate someone else's, the other participant in the act, their sexual gratification or needs. And so what the court said ultimately is that paying money for acting, as opposed to paying money to receive sexual arousal or gratification of the payor or payee, is not within the purview of the anti-prostitution laws, and so it was protected expression in terms of the right to make adult content. Now, the court also noted this: even if the defendant's conduct could somehow be found to come within the definition of prostitution literally, in other words, what the court was saying is technically money was being given and someone was engaging in sex while it was being filmed, right? Even if the sex wasn't with the person giving the money. So the Supreme Court says even if technically it can come within the definition, the application of this law to the hiring of actors to perform in the production of non-obscene motion pictures necessarily infringes upon First Amendment values. And that's at page 425. And so there we see this line between prostitution and the regulation of it and the line of the ability to make adult content. That's the line, and that's exactly why prostitution's illegal, but pornography movies are legal in some jurisdictions to be made. Now, we noted as a footnote there, as we were talking about adult content and prostitution in this overarching area of sex law, we noted obscenity. And obscenity is not constitutionally protected for viewing or filming. And so the history of the legal regulation of obscenity is actually quite fascinating because it's for years run up against the First Amendment and the scope of the First Amendment. We can start our odyssey down this road with Ross versus United States, which made clear from the U.S. Supreme Court that obscenity is simply not protected by the First Amendment. An obscene material is material that deals with sex in a manner, as Roth said at least, of appealing to the prurient interest. Now that narrower definition made, frankly, most pornography illegal if it was obscene, and so that definition has shifted over time because appealing to the prurient interest as a definition is not enough to regulate and make something obscene. And so copyright, protectable copyrighted works, in other words, adult content, now are able to be made, and they exploded because obscenity as its category became narrower and narrower over time, allowing the birth ultimately of pornography in full commerce as opposed to being under the table. So let's start with obscenity at the U.S. Supreme Court, because this is really where things get fascinating as we walk through how the U.S. Supreme Court has dealt with obscenity and the regulation of pornography over time. And so we'll start with the I know it when I see it test. This comes from Jacobellis versus Ohio at 378 U.S. 184 in 1964, and it comes from a concurrence by Justice Stewart. And so the facts here is that, and the facts are very common in all these kinds of obscenity prosecution cases, a movie theater owner was arrested and was convicted for showing obscene material, and the movie he had shown was the French film The Lovers, and it had a sex scene. And he was charged with that being obscene, and so under the obscenity criminal statutes was prosecuted, and it went up to the Supreme Court, and the Supreme Court reversed and said that adult movie, The Lovers, was not obscene. It wasn't the type of sexual content that could be so over the line as to be deemed obscene and hence prescribable and punishable. And the famous line, of course, there you see in bold is a quote from Justice Stewart that said, "I know it when I see it, and the motion picture involved in this case is not that." So this gave birth to the I know it when I see it test, as was colloquially and conventionally understood. And if you want a really fascinating look at this, you can go to Bob Woodward's famous book, The Brethren, which looks at the U.S. Supreme Court in the 1960s and 70s and is a fascinating walk down how the U.S. Supreme Court dealt with and addressed obscenity and obscene cases. And so we will start here by looking at the tests that came out of the Supreme Court in the 1960s and 70s from the different justices. And it's really remarkable stuff. And these are literally quotes from Bob Woodward's book, The Brethren. And in terms of how each justice looked at the material and decided what was prescribable and what wasn't. So for Justice White, it is, quote, "No erect penises, no intercourse, no oral or anal sodomy." For White, no erections and no insertions equaled no obscenity. And so that's how Bob Woodward wrote from his interviews with Justice White's clerks and all the people who knew behind the scenes how they felt. That was Justice White's obscenity line. Now, Justice Brennan, Bob Woodward writes the following, quote, "No erections. He was willing to accept penetration as long as the pictures passed what his clerks referred to as the limp DICK standard. Oral sex was tolerable if there was no erection." That's the Justice Brennan test. Justice Stewart famously has the Casablanca test. And this, as Bob Woodward writes, quote, alluding to what Justice Stewart said, "I know it," obscenity, pornography that is, "I know it when I see it." And in Casablanca, apparently, Justice Stewart had been a Navy lieutenant in World War II, and so he had seen, as the watch officer on his ship, many of the men bring back locally produced pornography. And so he said, based on his time in Casablanca, he absolutely had learned and seen and knew the difference between the hardest of hardcore porn and what came to the court in terms of where it fell. And so he actually called it the Casablanca test. We know it as the I know it when I see it test. Now, if you look on the next slide here, this is from page 198 of Bob Woodward's book, The Brethren. And it's really just some priceless, fascinating stuff to look at. I mean, it's if not comic and hilarious, but it highlights, importantly for us as lawyers, the real difficulty the courts have struggled with in defining and interpreting this line between what is permitted First Amendment expression of filming consenting adults engaging in sex and what's obscene. And as Bob Woodward walks through this book, you see the different perspectives those justices on the court took at the time, all male justices, of course, at that time period, but coming from their backgrounds, what they saw, what they understood. And as Bob Woodward talks about in his book, quite hilariously, I mean, Fridays were sort of porn day at the Supreme Court, where they would gather to start watching all these videos to start figuring out with their law clerks, is it obscene, is it not obscene? And this went on for a while. It's sort of like movie day at the Supreme Court. And so you see here, this hilarious little exchange, and this is again page 198, and so you have Bob Woodward saying, they're at Trader Vic's, I guess, eating or something, and Justice Marshall had launched into another story when he suddenly stopped. He looked at his watch. It was about 1:50. "My God, I almost forgot," he said. "It's movie day. We have to get back." I mean, you just can't make this stuff up. It's hilarious. And so movie day was the humorous high point, he says, of the term. I mean, the justices would get together in a room, start in the basement of the Supreme Court, start watching these adult films to figure out what was porn, what wasn't porn. And we've gone through the different justices and how they felt about it. But you see down here at the bottom of this, Justice Berger didn't like to participate at all, so wouldn't go. Some were sitting on folding chairs with their clerks, watching films projected onto the white wall. And really the hilarious part in this, which you can read at the bottom of this snippet from his book, involves Justice Harlan, who was by now very, very old. He was almost blind, actually. And so he was sitting at the first row a few feet from the screen, and he was only able to make out the general outlines because he was so blind at this point, basically. And so either his law clerk or another justice would sit next to him and describe what was going on in the film. And as Bob Woodward writes here so fantastically, and finally, Justice Harlan says, "By Jove, extraordinary." And that was movie day at the Supreme Court as they tried to figure out the line of obscenity. Now, movie day obviously didn't last forever, and it didn't work as a means to regulate the conduct of the American people and the American movie industry as it's making films. And so that kind of, I know it when I see it, let's all get together and try to figure this thing out test stopped working after a while, and it gave way to the Miller test, which is the test as we understand it today in different variations in terms of what is the line between protected First Amendment expression and sex and what's not the line. Miller's a 1973 case, which brings to an end our movie period in the Supreme Court at 413 U.S. 15. And the test that Miller settled upon is whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest, whether the work depicts or describes in a patently offensive way sexual conduct or excretory functions specifically defined by applicable state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. And that is generally the governing test today. It's taken on different barnacles and warts over the years in terms of kind of what the community standard could be and how strong a community standard can be to regulate something perhaps in one community versus another community, you know, comparing a perhaps a very small religious conservative community in the Midwest to sort of liberal anything goes Hollywood, for example, right? Those community standards are different, but there are still limits on that, and that's how the law has evolved since then. We're now going to shift to videotaping and laws related to the videotaping of sexual conduct, but also just videotaping other people with or without their consent, how you can videotape or not videotape. And I use videotape loosely. I don't literally refer to the traditional VHS video. It's your cell phone, it's your digital camera, all manner of now devices we have, from iPads to computers to camcorders. All of these things fall within the laws that we're talking about now when we talk about videoing. So videoing is shorthand for that. Let's start with sort of what are known as the peeping Tom laws. And these laws exist in all states, but we'll take a look at the first one, involving California Penal Code 647. And California Penal Code 647 refers to peeping while loitering, and it makes it a crime to peek in the door or window of any inhabited structure while loitering on private property. And one's in violation of this irrespective of what conduct they may have viewed. In fact, it's a criminal invasion of privacy under California Penal Code 647, which literally makes it an invasion of privacy under the criminal laws to engage in this conduct against other people. And so it prohibits specifically three distinct but very, very related crimes. The first is using a device such as a telescope or binoculars to invade a person's privacy, or your cell phone. Secretly photographing or recording a person's body under or through his or her clothing for the purpose of sexual arousal or gratification. Or third, secretly recording or photographing another person in a private room in order to view that person's body or undergarments. And that obviously comes up from many cases you've probably heard about before of people videoing other people somehow with hidden cameras in changing rooms in the mall and in shopping stores or in public bathrooms and the like. But in any event, in California, all three constitute a criminal invasion of privacy, which can put you in prison. Obviously, there are civil invasions of privacy too, but the statute's actually known as a criminal invasion of privacy statute. And so it's built around this idea of what's historically and colloquially been called the peeping Tom laws, to prohibit the peeping, of one person into another person's private, private property or, private body. Now, one question as we close out, we've started talking about videotapes and we're going to get into videotaping in full in a minute, but as we close out our sex component, we want to look at what is the most current state of law on obscenity. And it's particularly interesting to look at because some of the interesting cases that have not received full resolution may well now, with our new Supreme Court as it's been configured as of late 2020, may well be different in the future. And so remember, under the Miller test, obscene material can be regulated in terms of criminal laws relating to the distribution or public display. Now, one important point here is that private possession of obscenity is protected. Now, that doesn't include child pornography, but private possession of it can be protected under Stanley versus Georgia, which was a U.S. Supreme Court case from 1969 at 394 U.S. 557. And what happened in that case is as follows. There was a warrant that was issued by a judge, as a judge was, and the DA or whoever was looking into some financial crimes. And so as part of that, they issued a warrant. And the warrant was then executed by the police doing their, search, knock and search warrant business. And during the execution of the warrant, a whole bunch of 8mm movies were found. And these movies then were deemed obscene under state law at the time. And the possessor of the movies, the person who was being investigated for financial crimes, was then prosecuted and convicted under a state law that criminalized the possession of obscenity. And the Supreme Court reversed and said that if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch. And so the court ultimately held that the First and 14th Amendments and the right of privacy from the interpretation of the Constitution prohibited the criminalization of the private possession because the liberty interests of the possessor were too great. So someone could possess their material and couldn't be prosecuted criminally for it. Now, it's very, very rare in the last 20, 30, 40 years, in the 21st century certainly, to see prosecutions for simply possession of adult sex films. But they do occur if you have material that goes beyond sex and involves sort of sex films with significant violence or, certainly child pornography, but even sort of very, very odd sexual behavior, I guess one could put it. Those can trigger some prosecutions. But here's a fascinating open question in the law currently. And it's an open question in terms of, can someone possess literary works that are obscene that are not video films, for example, but something that would meet the test of, for example, child pornography, but in a written fictional work? And so this is the Red Rose case, and it involves writings about fictional child molestation. And this book, I guess you could call it, or these writings by the fictional, these apparently fictional writings about child molestation, led to a prosecution in 2007 of the person. And he pled guilty and got 5 years probation. And one of the challenges made was whether state criminal laws can outlaw and can lead to a prosecution of fictional obscenity writings, or whether the First Amendment would allow someone to engage in the act of writing fictional stories about, for example, child molestation or other obscene material that would normally be prescribed by the First Amendment. And there was no full resolution, but of course we were dealing with a very, very different Supreme Court in 2007 versus 2020. And so as we look at sex law in the future, this is one of those issues that we may well see, along with the general rules on obscenity and sex regulation. We may see some of these cases now in the new Supreme Court we're looking at in 2020 and beyond. We may actually start seeing some of these cases get taken up to the Supreme Court, and we will look at sort of sex law 2.0 in this latest generation, as we may well see some changes in the law and the standards across the country in terms of what's obscenity, in terms of especially the nexus of the internet and adult pornography as it relates to the Digital Millennium Copyright Act and the ability to upload millions of adult content videos on the internet, which can be viewed by children, obviously, if they can get on the internet anywhere and everywhere on these aggregator pornography websites. And so these types of issues have not been taken up by the US Supreme Court in the last 20 years, but they're on the horizon and they're ripe to be taken up. And so I think that's where sex law stands today. Let's now shift in full force to videotaping. And our portion of the program here is going to get at the videotaping involving the recording of others, whether it's sexual or otherwise, and the legal regime that sits above this act of videotaping and video recording. And again, as I mentioned earlier, videoing is referring to the use of any device to record audiovisual content of people engaged in sexual behavior. And so as we talk about videoing, it's not just sex, although it can involve the videoing of sex. And so the first component of what I want to talk to you about is videoing as it relates to sex, and then we're going to pivot for a while to non-sex related videoing, whether it's public or private. So let's start, though, picking up on our pornography section we just did in terms of filming of sex acts and federal criminal and copyright laws that exist here. And this, of course, gets to the general rule we spoke about, which is they are generally protected within the First Amendment, and thus not only do people have the right to make these works within the First Amendment and not be prosecuted under sex laws, but under our civil laws that govern recording, right? The recording of me right now is creating content under copyright law. When Steven Spielberg makes a movie, he's creating copyrights. Well, these adult films have a nexus with copyright law also. And copyright law protects the creation of these works because they are not prescribable works under the First Amendment. Now, there is a whole bunch of federal legal regimes that sit around the creation of adult content that doesn't apply to Steven Spielberg when he's making Jaws, for example. When adult filmmakers are making adult content, there are these federal criminal laws at 18 U.S.C. 2257 that have stringent requirements to verify and confirm the age of the actors to make sure they're all adults. Labeling requirements exist in terms of affixing labels to the actual finished audiovisual work to make sure that it's labeled and stamped and marked as adult content in the beginning and the end, so that as it begins playing, people know that they are about to see adult content. Those types of labeling laws exist. And of course, as I alluded to briefly a moment ago, now that we know we have a copyrighted work that was done with a legal age adult performers that complies with the federal standards, it's now a work eligible for copyright protection. And this then gets to, copyright laws and the intersection of copyright, especially with the internet today. And so copyright, just as a brief reminder, protects the creation of original works of expression that are fixed in a tangible medium of expression. And the originality requirement is a very, very low bar. There's no requirement that you make, a brilliant, breathtaking movie, the farcical scenes that can be put together to make adult content, and then the adult content itself qualifies under this sort of minimal originality standard. The courts have never historically wanted to peer too deeply into whether something is of sufficient artistic quality or not to merit protection. And so the originality standard's very low, and so these works we're talking about qualify. The second requirement to actually have a copyright, so that in your videotaped work, so that you can have a copyright, is that it be fixed in a tangible medium. And this simply requires the recording of it. So when you hit record on your iPhone, for example, and film whatever it is you may film, your cat, playing with a toy, the moment you hit record, you have fixed in a tangible medium, that digital file in your phone. You have fixed that expression that you're capturing. The cat's running around, you've picked your angle and your lighting, and you then play with it and make it chrome or monotone or whatever you do, Sophia, whatever you may do, right? You've now fixed in a tangible medium your work. So you have a work that is eligible for copyright. And now your copyrighted work has been made, and you sell it, you put it on YouTube, whatever you may do with it. And if we're talking about adult content, it gets packaged up and sold, behind firewalls or on DVDs when and if they even make DVDs anymore, or for digital access over the internet. And one of the issues this triggers heavily is the Digital Millennium Copyright Act and its nexus with adult content on the internet. And the Digital Millennium Copyright Act allows companies that host websites to have immunity from copyright infringement if they comply with certain strictures under the DMCA. And those strictures, as you can see, involve things such as if you have repeat infringers, having a proper policy to terminate them and to cancel their website, verifying that if you get repeat uploaded content, you remove it. If someone complains that their copyrighted content has been posted, you expeditiously remove that content and disable it from coming back again, and the like. So outside the adult content, the sex content, you can just think of YouTube, right? I mean, Google now owns YouTube, but when YouTube started, it's just sort of a blank digital canvas. Anyone and everyone can upload all manner of videos, however, silly, inane, brilliant, creative, whatever. They just upload them to YouTube. Now, that's great for YouTube making all of its money on ad revenue, but when someone uploaded Star Wars, it wasn't great for George Lucas. And so George Lucas was able to say, hey, look, YouTube, you may not be liable for the infringement of displaying and publicly, providing access to my movie because of the DMCA that immunized YouTube. But YouTube had to take certain steps to maintain that immunity. And those steps are under the DMCA. Now, let's be very clear. The person who uploaded that copy of Star Wars, if it wasn't George Lucas or Disney today, I guess, that person's an infringer, and that person can be liable if they can be traced and it can be figured out who they are. And so the DMCA, though, protects the service provider. Well, as we go to the sex context, what has happened is a massive proliferation has occurred of sites that you can think of them as YouTube, but they're for pornography. And there's all manner of them that have billions of uploaded clips of adult content, which is ripped from DVDs or other sites from the original creators. In other words, those who own the copyrights have their works infringed, uploaded, and then they can be viewed on the internet by anyone and everyone. And so the adult content world, in terms of regulating its content now online, has to deal with infringement and protect against its works being infringed by navigating the Digital Millennium Copyright Act to get those sites to either take down the content or block access to it, or if the account is a repeat user who terminates, to have that account terminated. And as you can see on the next slide here, one of the massive cases that went to the Ninth Circuit happens to be a case I litigated and I argued in the Ninth Circuit, where we had represented an adult content company trying to deal with one of these online tube sites, for lack of a better phrase, that was dealing in trafficking and infringing content. And so you can see on the slide here some of the basic facts about my case, but my client's adult content that was made complying with all the laws, obviously, was infringed and uploaded by people who uploaded hundreds of thousands of different files. And so we sued to make the argument that the service provider itself should not have immunity within this realm of sex law for its act of displaying all these films, because it was knowingly taking too much content from people who were just infringing endlessly and repeatedly. And we lost a summary judgment. We went up to the Ninth Circuit. I argued this case before the Ninth Circuit, and you can see on the slide here this quote from the majority and the quote from the dissent. Ultimately, we lost the case, and the court gave copyright immunity and the safe harbor to the service provider, the same way Google and YouTube and Facebook and all these service providers do have immunity by and large. We were not able to break through the shield of immunity against this service provider, although we believed we should. And as you can see here, the dissent believed we should, and believed that this service provider was not like YouTube or Facebook eligible for immunity and should be liable for the copyright infringement occurring on its site. And so you can see here the quote from Judge Rawlinson in the dissent. But it was 2-1 and we lost. Now, interestingly, as a postscript here, since we're talking about videotaping and the like, The US Copyright Office just in 2020 issued a white paper. And one of the issues the Copyright Office raised was this decision in the Ninth Circuit, my case that we litigated and that I argued in the Ninth Circuit. And the Copyright Office concluded that I was right, the dissent was right, and that Congress, if not the Supreme Court, didn't take our case, we tried. And so therefore the Copyright Office said Congress needs to revisit these copyright laws as they regulate the transmission of video content over the internet, and needs to rewrite the laws to start limiting the immunity and protection of the safe harbors, because this Ninth Circuit decision was just wrong and the dissent should have been right within copyright law. And so it was a fascinating issue, and I think as a result, it's a big deal for the Copyright Office to say that. It does portend massive shifts on the horizon, if not legislatively, then by the Supreme Court, in terms of how it deals with immunity. And as you all know, there's a massive amount of questions now on the line as it relates to immunity for all the content that's blowing across Facebook and YouTube, in terms of tort immunity, in terms of regulating speech of others, and this is a big issue that's obviously been in the press and before Congress. And so I think on the copyright realm, as it relates to videotaping, we will see changes starting post 2020 on the horizon too. Now, we can shift from sex at this point in videotaping to just traditional videotaping. As we look here at the issue of police and cameras, we are exploring the intersection of the First Amendment in terms of creating expression in public of things happening in public and what are our rights to record in public. It's intersecting with copyright law, obviously, because who is the author of that created work is a question. And we're looking, of course, at sort of wiretapping issues in terms of cameras and the recording and tapping of other people. So you see here a picture, and this is a picture of a cop approaching some people in public, and getting ready to arrest them or taser them or something of the like. And the picture was taken. And so what the general rule is when it comes to videotaping in public is that the taking of photos or recording of videos of things in public spaces is protected speech. And this means buildings, transportation, the police, government officials, sidewalks, people doing their duties out in public are available to be filmed while they're out and about in public and they're doing their thing and you can film. And that is sort of the part of the reason for this First Amendment right is the check and the balance on police behavior, but also this is a public forum and public square and you're allowed to film. And so this takes us to the next slide, which is street photography. If we broaden the lens, so to speak, from the recording of police engaged in their duties, or the mayor giving a speech, or digging a hole in the ground to plant a tree, or whatever it is that mayors do, right? If we go from there to just general street life, right? What's going on Venice Beach, or down on Balboa Island in Newport, and you want to just record public life on the public beach or the public street, this touches rights of privacy laws that do vary by state. Now, generally, like with the police, in all states you can photograph people in public who are on public streets, for the reason that when we all enter the public sphere, we shed any reasonable expectation of privacy from being able to be recorded. So if you're walking down the street licking an ice cream and someone takes a photo of you, that's okay. If you're sitting in your backyard licking an ice cream and someone sort of from the sidewalk uses a lens and takes a photo of you doing it, that's not okay. The reason being, when you're in your backyard licking an ice cream, you have a reasonable expectation of privacy. But when walking on the street, you just don't. That's part of the quid pro quo in our free society. And so photos of street life are open to all of us to take with our cameras. Now, as a footnote, we should note, what you can do with the photos is of course limited. If you see, for example, and we'll talk about this in a little while, but since we're talking about public streets now, I want to give you an important tip. If you see, for example, Jennifer Aniston walking down the street licking an ice cream, you can snap a photo of her in public. Now, if you're Ben & Jerry's and you want to throw up that photo of Jennifer Aniston licking the ice cream to help sell your Ben & Jerry's ice cream and trade off of her persona and her goodwill eating the ice cream in public, you can't do that, because now you've tripped her right of publicity to control the use of her image for a commercial exploitation. So it's one thing to take photos for sort of personal or artistic reasons and background shots for news and whatnot. It doesn't mean you have the right to stalk out, capture a celebrity in public, and then be able to use that person to commercially exploit them in your commercial endeavors. And it's true for even a private person. So, you know, photograph me licking an ice cream on the street, not that you'd think that would give you any value, but if you did, you would be tripping my right of publicity if you tried to sell skincare creams to someone with my picture licking an ice cream, or sell ice cream or whatever. So you get the point. Those photos you take, though, of the public, you can then license and sell to stock art agencies. And so there's loads of stock art agencies on the internet, such as, you know, Getty and iStock Photo and the like. And all of them do buy and acquire these stock images that get used for a whole variety of reasons. And so that's where a lot of this stock art comes from. It's just people snapping photos in public. So now let's shift, since I was talking about Jennifer Aniston and celebrities, let's shift to street photography of people and celebrities in public. And as I was mentioning on the ice cream example, there's limits to what you can and can't do. And so here you can see an example of Katy Perry walking along smoking her cigarette in her bikini. And here she's at an amusement park, a water park. In this photo, I have a license to use, by the way, just so you know, and my client took it and allowed me to use it for this educational program. And so my client was a celebrity photo agency and got this photo of Katy Perry in public, smoking her cigarette, walking in her bikini, and the like. And so that is a legitimate right of the photographer to take the photo, and then it can be sold or licensed to People magazine and celebrity magazines and whatever to show, you know, Katy Perry in her bikini, because the world wants to see the celebrity content. Now, as you see, as we move across these images, you can trip lines if you're not careful when you take that image and use it in public. And so I gave you the Jennifer Aniston ice cream hypothetical we made up, but here's a real one of a real celebrity who was out shopping in public, and, you know, the people loved what she was shopping with her bag and whatnot, her jacket, and then used that to advertise the products itself that she happened to have. And now you're associating that celebrity with your products, which you cannot do just by virtue, just because she happens to buy your coat, your groceries, your ice cream, doesn't mean you get to now associate her with your product absent her consent. And so that was snapped and used by the brand online, and that created liability and trouble for the brand online by doing that of that celebrity. Let's move now to the zoom lens rule. As we're talking about street photography of people in public, the question, of course, comes up, are you in public or are you not? Who's in public, who isn't? Does it matter where the recipient of the photograph, or that is the photography, is, or is it where the photographer is? And so California has what's known as a zoom lens rule. And in California, a zoom lens or other technology to see that which the naked eye is not seeing cannot be used, even if from a public space vantage point, to peer into a private place where it invades the reasonable expectation of privacy. And so obviously, this idea of videoing with zoom lenses, you know, you imagine in the old days people in trees with a lens trying to peer into a backyard, you know, then it was helicopters, now it's, you know, tiny little drones that can go anywhere, basically. If you're doing that to video people in their backyard sunbathing and the like, you can't do it. You're invading their privacy. But here's a fascinating question coming from New York. What if you're doing street photography of people who, they're in private, they're in their houses, in other words, but they're completely visible from the public. And this comes up particularly, you know, because they're like literally abutting the window of the house to the public outside world. And obviously in a place like New York with high-rise apartment buildings, anyone standing at the window of their apartment looking out is highly visible to those outside. Do they have an expectation of privacy against being recorded there? And this came up in this famous case of Arne Svensson, who was a photographer in New York who surreptitiously took loads of photographs of people across away from his high-rise building. And he was in a high-rise building, he looked out, and he saw all sorts of people just living their lives in their apartments. And so he took all these different photographs of people just going about their business in their apartments, completely visible to the public world because, you know, he wasn't invading their privacy with a zoom lens or drone or the like, but he took photos, and he wanted to compile these photos to fundamentally comment on, you know, from his perspective, the anonymity of modern life as everyone's trapped in their little, you know, houses or spaces. And he was commenting on just sort of the anonymity of modern life as we go about our loneliness in our little apartments and our existence. And so he took all these photos and he released them as a series that was called Neighbors. And this led to litigation because he was sued for invasion of privacy by some of the people whom he photographed. And, they claimed and they sued because they had never consented, and they said this is an invasion of privacy. Now, he voluntarily took down some of the photos of children that were taken, and that was, voluntarily done by him. But as to the rest, he said, no, I have the right to take these photos. They're not being used to sell ice cream or for other trade purposes. This is sort of part of my artistic show, and I want to be able to, show the world these photos as we comment on, the anonymity of modern life in apartments. And you can see there just a couple of the photos. Just, it looks like a woman bent over in her dress. Maybe she's scrubbing the floor or something. There's some guy with his shirt half hiked up his back, asleep on a couch, with his rear side to the window. And the court went to the New York Court of Appeals because they lost in the trial court. But the New York Court of Appeals said no. You cannot stop the artist from taking and using these photos in this manner, precisely because they weren't being used for trade. And so there is no sufficiently reasonable expectation of privacy to prevent against that being done for those artistic purposes. And so that's the famous case of the neighbors showing in New York. Now, as we're talking about consent standards for recording people in private spaces, we now shift to California. We're going back west again. And California, like many states, has what's called a two-party consent standard to record other people in private conversations. And that means that if you're in California and you're having a conversation with someone and you want to record it, both people need to consent. You can't just be the one giving consent as the one clicking record on your phone. If you don't get consent, it's a crime. It's punishable, it's a misdemeanor, and it's under California Penal Code 632. And it can also lead to civil liability and a $5,000 fine against the person you recorded inappropriately, as well as what other damages or liability could attach. Now, not all states have a two-party consent rule. Some states, such as New York, have a one-party standard. So the person holding the phone recording the other person can do it without telling the person, and that's okay in New York. And so what that means is, in New York, if you're having a conversation with someone, you should not have a reasonable expectation that it's not being recorded, and you should be probably careful what you're saying if it matters particularly. Whereas in California, because it's a two-party consent standard, you have a reasonable expectation that you're not being recorded. Now, if you apply this to the sexual conduct space, you will trip invasion of privacy, common and statutory laws if you do it without consent, even in a one-party consent state. So this comes up in the context of New York, for example, and the case of People versus Pisnarski on the next slide shows this. And what it shows is this intersection between the idea that New York's a one-party consent state, so I can record my conversation with you, but can I record myself having sexual relations with you without telling you, under the theory that, oh, it's one-party consent, I get to do it. Pisnarski tested this, and so he recorded consensual sex without his partner's consent. He was arrested and prosecuted, and his criminal defense argument was that we're a one-party consent state, so I have the right to video record and audio record my sex with someone else without them knowing or even consenting, the same way I can a phone call. And the New York Court of Appeal rejected this, and they said that while it's true we're a one-party state when it comes to audio recording and eavesdropping statutes, this is different because it's unlawful surveillance. And the unlawful surveillance laws require that the person being video recorded in this way must consent to the taping. And it would make these laws null and void if the surreptitious surveiller only had to consent. And so this would also include, actually, the audio recording of engaging in sexual conduct as opposed to the audio recording of a conversation, because of the interplay of the surveillance laws and consent when it comes to sexual conduct and just your regular conversations. And so Michigan and Indiana courts have found the same, it turns out. This brings us now to revenge porn laws. And so revenge porn is the issue of, people who've engaged in consensual sex and recorded it, maybe even consensually recorded it. Both people said, hey, yeah, let's record our sexual conduct. What happens when they break up and then one person gets upset and releases it? And this is what's become known colloquially as revenge porn. And as it stands today, 46 states, a U.S. territory, and the District of Columbia have criminalized the dissemination of even consensually acquired sexually explicit material if the other party doesn't consent to its public dissemination. Now, there's a pending federal law designed to address this at a federal level and just criminalize it. And this pending federal law has been around since around 2016, but it was brought back to the forefront in 2019. You may remember when the big brouhaha happened with Representative Katie Hill, freshman congresswoman, where some sexually explicit material was released in sort of what was explained by her campaign to be revenge porn by her estranged spouse. And this then led to the reintroduction of the bill after that brouhaha, and she stepped down from Congress because of that and some other issues, obviously. But Jackie Spear from California has reintroduced this bill designed to criminalize and punish what is colloquially known as revenge porn. And this is, as you see on the next slide, the proposed Intimate Privacy Protection Act. And the bottom line here is that it looks to, at a federal level, criminalize the dissemination of this type of content without someone else's consent. So it's already criminal in 46 states, territory in DC, but if you happen to be in one of those few states where it's not, expect a federal law sometime soon, probably as we get past 2020 and this gets back on the table. So now we are going to shift from our topic of sex and videotaping to the last part of our trilogy today, and that is the issue of lies and the laws relating to the right to lie, which is kind of an interesting concept to think about. We don't talk about it a lot as lawyers in legal education and legal circles, but we do want to explore whether we have a constitutional right to lie. In other words, are we obligated to tell the truth all the time, or is lying itself constitutionally protected because we have that right to engage in lying if we want to? And the answer, like all constitutional questions, is it depends. And so there are contexts where you absolutely have a constitutional right to lie, and there are contexts where you do not. And so let's start exploring those. We're going to start with the Stolen Valor Act example, and this is a federal statute that was passed on the heels of people going out and claiming in commerce that they were, military veterans, they were decorated soldiers, they had great military achievements, and they're making these claims when it turns out they hadn't achieved those things. And so Congress passed the Stolen Valor Act, as you see here. The act is really broadly written. There's no intent requirement in the statute, it turns out. If simply a person makes a mistake saying that they had received a Medal of Honor, but it wasn't, for example, maybe it was a Purple Heart, they really are a decorated veteran, it could technically trip the law. And so you had this very broad law designed for the policy purpose Congress wanted to prohibit lying about one's military background. And the result of this law is that it led to litigation, of course. And the litigation is, as you see on the next slide, the case of U.S. versus Alvarez, 567 U.S. 1209. And this is from 2012. And I should note as background here that the Stolen Valor Act came out of incidents coming on the heels of 9/11 and then the wars that began thereafter. And so this case involved Javier Alvarez, who was a member of a water district board in Claremont, California. And he, as a member of the board, introduced himself and said, I'm a retired Marine of 25 years, and this is his very first board meeting as a public official. I retired in 2001. I got the Medal of Honor in 1987. I was wounded many times in battle and the like. And it turns out it was all a lie. He'd never done any of it. And this got exposed. And then he got indicted by the United States government, by the U.S. attorneys, under the Stolen Valor Act. And he pled guilty, but he reserved his appeal to challenge the constitutionality of the law. And this then goes up to the U.S. Supreme Court in 2012. And you can kind of understand where this begins with the quote you see here from Justice Kennedy, who began the plurality opinion by saying lying was his habit. So, we're dealing with a guy who's just lying, and he was lying to gain the public currency and credibility one could get as a public official. Now, the problem with the case is it spawned multiple opinions and multiple different perceptions among the 9 Supreme Court justices in 2012 as to what was the line and what was appropriate. The government's core argument you see here, and this is from Justice Kennedy's plurality, which won the day. The government's argument was that false speech doesn't add any value to society. And so because it's without First Amendment, because of that, it's without First Amendment protection. The government argues specifically that false statements have zero First Amendment value in themselves, and therefore they're protected only to the extent that may be needed to avoid chilling the ones engaging in protected speech. Now, 6 of the court justices rejected this, and they found that the Stolen Valor Act was unconstitutional. But even though 6 said it was unconstitutional, there wasn't a majority opinion. And so Kennedy wrote a plurality opinion for 4, joined by Chief Justice Roberts, by Ruth Bader Ginsburg, and by Justice Sotomayor. And Justice Kennedy's plurality opinion rejects the government's claim that lies are without First Amendment protection. He did, however, acknowledge that there were prior discussions in case law, obviously dealing with defamation and fraud, that does allow, of course, punishment of false speech. But he said, the court has never endorsed the categorical rule that the government advances here, that false statements receive no First Amendment protection. Instead, Justice Kennedy said, quote, "We've rejected the notion that false speech should be in a general category that is presumptively unprotected." So he said to allow the government to punish false speech would have a chilling effect on expression. That, of course, was the plurality. Now, on our next slide, we can see Justice Breyer's concurrence. He concurred, and he was joined by Justice Kagan. But he disagreed with the strict scrutiny used by the majority and said that here, the lower scrutiny level of intermediate scrutiny should be used to describe what the court should do. And it should have some sort of proportionality review. He did agree that the government's claim was wrong, but he actually went further and said that there are benefits to lying in some contexts. And you can see his quote here. "False factual statements can serve human objectives. For example, in social contexts where they may prevent embarrassment, protect privacy, shield a person from prejudice, provide the sick with comfort, or preserve a child's innocence. In public context where they may also stop a panic or otherwise preserve calm in the face of danger." So he gives several examples where he believed actually that lying could even serve a social benefit, so it shouldn't even be presumptively subject to any kind of regulation at all. And so he emphasized here that this act was so broad and the government could achieve its goals in much narrower ways by adopting a law that prohibits, for example, claiming a military honor when one hasn't falsely, right? That could give some specific benefit and be a narrowly tailored law. Now let's go to Justice Alito's dissent, joined by Justice Scalia and Thomas. They said that Congress has confronted an epidemic of false claims about military decorations, and Congress did adopt a narrow statute, and so he said the majority has simply abandoned the long line of cases from defamation regulation and fraud regulation, perjury regulation, that absolutely allow the government to prohibit lying. That the court now, the dissent said, has abandoned that and recognized under principles of free speech that people can simply engage in false factual statements designed to benefit themselves sort of politically. And he said, no, Congress can regulate that, especially where they're inflicting harm and it doesn't serve any legitimate interest. So, as you can see on our final slide here about this case, the holding of the case was sort of an emphatic decision between the plurality and the concurrence that there is a right to engage in general in false speech, and that right is protected by the First Amendment. Now, there are limits, of course, and that's perjury, oaths, and defamation, and I'm going to talk about that briefly right now. But one thing to keep in mind is that case could be very different in the coming years, given Justice Kennedy, Justice Ginsburg, and Justice Scalia are no longer on the court. Let's talk about lying to the feds in informal talks. 18 U.S.C. 1001 makes it a crime to knowingly and willfully falsify a material fact when speaking to a federal officer. And this has a very harsh criminal penalty for lying. Now, note, this is not where you've sworn to take an oath and tell the truth and you're being prosecuted for perjury. This is for simply an FBI agent coming and saying, I'd like to ask you some questions, and you say, okay, what do you want to know? And then you give a false material statement knowingly to the FBI. At that point, you can actually be prosecuted under criminal law for lying. And so let's look at this statute of 1001, because it has expanded greatly over time. It goes back to 1863, where really it dealt with claims against the government. And then it was amended in 1934 to apply very broadly, or more broadly at least, to any persons engaging in matters within the jurisdiction or departments of the U.S. And so under a case called U.S. versus Bramblett, the Supreme Court said that this would involve lying to departments or agencies of the government. Now, by the 1980s, this got broadened further during the Iran-Contra hearings and in the litigation fallout that came. Judges held that 1001 could expand to lying even in, by making unsworn statements to Congress or inter-branch unsworn lying statements. And so as it stands now, 1001 is very, very broad. And the key point, as you can see on the next slide, is that lying can get you in trouble to the FBI. And so here's the basic practice tip that we should give our clients. If FBI or federal officials or agents come and say, hey, we need to ask you questions and want to talk to you, the response should be, no, I need to get my lawyer first. And you should filter it through a lawyer, because the act of answering questions, if you say something falsely or wrongly, which can happen inadvertently or because people are nervous, could actually now create a crime out of that act, even if what you were talking about turns out wasn't a crime. And this is important because, as you see on the second bullet point here, people can get ensnared even if the underlying conduct turns out not to have been illegal. And so the famous case, of course, of recent years is the Martha Stewart insider trading case. She had made some trades in some stock, and the SEC and the feds came along and wanted to talk to her about it and inquire about these stock trades that had been made. And in the course of communicating with the feds, they decided she had lied. And so she got indicted for lying under 1001, obstructing justice and lying to the feds in the investigation, and for securities fraud. So their theory, at first at least, was you've lied about securities fraud. Well, it turns out eventually they dropped all the securities fraud cases because it turned out whatever she had done or she thought she did, it technically wasn't illegal. So she had never tripped any wires, even if she thought maybe she had. But she went to jail for lying. So as you see there, it's not the crime, it's the cover-up. That brings us to an end. You can see on our conclusion slide here some basic points to keep in mind. Sex and the recording of it and others is heavily regulated conduct, so be careful. There may be open questions on the constitutionality of laws prohibiting adultery, but nonetheless, engaging in and videoing in any sexual content with others should be a very careful thing, and recognize that you don't get to disseminate the content even if you got consent to record it, because consent to disseminate is a different question. There's a massive line between public and private spaces depending upon jurisdictions, as you saw with our California Zoom lens versus our New York neighbors art case. And remember, there is a right to lie in some contexts. Not in all. You can engage in defamation or trademark infringement, for example. But you also need to be very, very careful, because although you may have a right and the court may perceive a right to lie in general, 1001 of Title 18 can make it a lie to the FBI even if what you're lying about wasn't a crime itself. So be careful, get a lawyer. That's our presentation. I hope you enjoyed Sex, Videotapes, and Lies.